SJC-13202, Commonwealth v. Joseph Pope.
Okay, Attorney Harris, when you're ready.
Good morning, Your Honors, Madam Chief Justice, and may it please the Court. My name is Jeff Harris. I'm here representing Mr. Joseph Jabir Pope, who is in the courtroom here with us today. Mr. Pope is here having spent 38 years in prison on a wrongful conviction, having been convicted on a crime where the parties agree that he had no intent to kill, and yet he was given a first-degree life sentence. Mr. Pope did not get a fair trial. The Commonwealth withheld significant impeachment evidence concerning, in part, the only percipient witness to the trial, to the murder, Benny DeJesus. This Brady claim presents two central issues, disclosure or non-disclosure and prejudice. And unless this court has specific questions they want to go to immediately, I will take those in turn.
Can I push you on the prejudice first? Because I think the disclosure issue will bang away at the prosecutor for a while on that. But so I read the transcript, I read the cross-examination, I read the closing argument, and Mr. Kelleher does quite a nice job of showing that Benny is a drug dealer, and that Benny may have taken the drugs remaining in the house to his girlfriend's after the shooting. And then the third point is whether he's upstairs or downstairs, whether your client is upstairs or downstairs. And on that third point, if he's downstairs, that seems to be more inculpatory than if he's upstairs, because he's then downstairs for the shooting. So tell me where the prejudice is, because I see your point on disclosure. I have difficulty reading this transcript and thinking that Mr. Kelleher had that information, but I don't see the prejudice yet.
Sure. I think the prejudice comes in two flavors. First, there's the things that the defense didn't know that they could have presented at trial. And secondly, there's the way in which the prejudice is compounded by the Commonwealth in its closing, specifically because it benefited from that non-disclosure by essentially telling non-truths to the jury at the end. So I'll start with the things that the defense didn't know. The defense didn't know that Benny had told a different story on the night of the murder. So Benny tells a story about, for instance, Hamilton being upstairs. And the defense could have said, you never said that on the night of the murder, did you? They said that he had a shotgun. Never said that on the night of the murder, did you? That Mr. Pope, quote, pulled him down into the drug room at gunpoint. You never said that on the night of the murder to the police, did you?
I'm sorry, didn't the Flynn report say he was upstairs?
I'm sorry?
Didn't the Flynn report of Benny the night of the murder say he was upstairs?
The Flynn report, which is a very conclusory document, which wouldn't have provided much fodder for cross-examination, I would submit, actually, the Commonwealth is arguing that the Flynn report suggests that he was downstairs, and because of that, that the defense therefore...
Benny started to go downstairs.
Right, so it suggests...
That suggests he's upstairs.
It suggests Benny's upstairs.
Benny's upstairs.
But what the Commonwealth is arguing is that suggests that Mr. Pope was downstairs, and because of that, they could have used the Flynn report as cross-examination. If you look at the Goodell documents, though, there's no question in those documents that it says Mr. Pope went downstairs and then he walked back upstairs.
And please don't,
I'm sorry.
You were answering Justice Kafka's question about two prongs, prejudice, what they knew,
Sure.
and then what happened in closing argument. So please continue along those lines.
So I was kind of going through some of the prior inconsistent statements that maybe could have been made about Benny. you didn't say anything about the fact that cocaine was stolen from you upstairs in that drug room. You could have said these things to the police, but you didn't. They would have been able to say, you said one story here, and now you're saying a different story, and these are very different things. It's also, and I think you have to look at the totality of.
Stop you on that point.
I'm sorry, yeah.
Talk about the Goodale memo for one moment, and the Commonwealth brings this up in the context of disclosure. They make the point that maybe they had the notes, maybe the defendant had the notes, and they recognized that they couldn't use the Goodale memo to impeach. I mean, you can't use somebody else's memo to impeach another witness.
Well, I think if you're talking about disclosure,
Well, I'm talking about
Talking about
both.
disclosure, you're talking about prejudice.
So I alluded to disclosure on their argument that
Right.
there might have been a rationale
okay.
for not, because there was the request for notes, but put that aside. Ultimately, Goodale has this memo, and it seems to satisfy Brady. There's exculpatory information in it. If it wasn't turned over, it should have been turned over.
Right.
But ultimately, how can the Goodale memo be used to impeach another witness?
Well, the Goodale memo is not just impeachment material. It is also a roadmap to the defense that Mr. Pope wanted to make. So he was trying to argue that Benny was lying, that cocaine was found, and that he basically changed the story. He's unreliable because he wanted to curry favor with the police. They found cocaine. The defense didn't know that they found cocaine, but they found cocaine. That would have been a basis for saying he's trying to curry favor with the police because he has criminal exposure.
I understand your argument is that it doesn't have to be admissible to be Brady material. It has to be helpful to the defense, and it's helpful to the defense to know that Benny's all over the place.
Right.
Right? What happened during closing argument that you wanted to tell us as well?
So three things really compound the non-disclosure. For one, throughout all three trials, they said there's no notes of the interview. There's no record of this interview. But including in the closing, they said there's no record of this interview. But that was not true. There was record of the interview, and they benefited from that. They said that Benny was not a dealer in the closing. They said that Benny was not a dealer, and that no cocaine was found in the house after the murder. But they knew that cocaine was found in the house. They knew because Robert Flynn had told the ADA. So to say that in closing is just not true. It's beyond the pale. It's hugely prejudicial. And then they also knew that there were prior inconsistent statements. I'm sorry.
Why is that it's evident that cocaine's being sold out of this house. There's no question about that, right? So what, and the issue of the brothers are both complicit in this, the victim as well as the witness. And you even, at one point, Kelleher shows that Benny says he'd lie for his brother. What difference does it make whether they find the cocaine there or not? Because we know it's a cocaine deal going on there. The question is by whom, right?
Well, they allege that he stole the cocaine. And then they go in after the murder, and there is cocaine. I mean, at the very least, this is a fact that the defense should have been able to say to the jury, the Commonwealth has said he stole cocaine. They go in, and there is cocaine.
What happened with Detective Curran's testimony at the probable cause hearing that there was cocaine? I know that he testified differently at trial.
Now, right. So I think what's really important for this court to recognize is the police find cocaine, and then over the course of a probable cause hearing and several trials, the cocaine kind of magically disappears, which is
burnt in the probable cause hearing.
Right.
And then
First,
it's
some substance,
right,
according to Curran, and then over the course of the trials, it goes from empty packets to some substance to empty again. And it's sort of like they needed the ability in the beginning to say, we have cocaine and we can use this against you, but then we didn't want to have promises, inducements, or rewards that might have been revealed about Benny, so they got rid of the cocaine.
A stupid question, forgive me, I think. Were the photographs of the crime scene that were introduced during the trial that would have shown what was the state of the evidence upstairs?
No, there are photographs. There's plenty of photographs in the police record. There's no photographs of the drug room upstairs.
Okay.
But yes, a lot of that is in the exhibits, and they're available to the court if the court would like them.
Thank you. And the other second question for me is, assuming that this is exculpatory Brady material and it should have been disclosed because it shows, not that it's admissible, but it shows inconsistent material statements by the main witness, how do we get the Mazza violation where Kelleher's obviously passed away and his file's gone, and now we have to intuit that they didn't have the good deal documents?
Yeah.
And we have to do that by looking at what Kelleher did?
I think Justice Kaffer is absolutely correct to point to that as the controlling case here. I point to a number of things. First of all, you have 3 trials, you have hundreds of pages of transcripts, you have 3 defense lawyers, you have 2 defendants, you have appellate lawyers, et cetera, et cetera. Throughout all the pleadings, throughout all the transcripts, never one mention of this document. There's no sidebar, there's no voir dire, there's no motion in limine even to make the argument that Justice Lowy is making that these statements should come in for some reason, like for instance, if they had put Detective Goodall, ADA Goodall on the stand to see, because maybe he had said these things directly to him, and they could be used to impeach Benny. It's possible that they could have made these arguments. They never made the arguments at all. Of course they didn't have these. These were prior inconsistent statements. The Commonwealth at the end of the trial, this is perhaps the most prejudicial thing that they do, is they say, Benny, there's nothing that Benny said that's different from what he said at trial. That means, even though they know he gave prior inconsistent statements to the police from the night of the murder, that absolutely hammers home the prejudice of not turning over prior inconsistent statements. So as far as non-disclosure, I'm sorry, getting back to the non-disclosure, it's never in any of these
Do you know, and I'll ask Mr. Lynn, but do you know whether or not, I know it was the practice of the Suffolk DA's office at that time to have ADA response to homicide people. Do you know that back then, was it a practice to turn over those notes or those to from reports to defense attorneys, or is it something that was never disclosed? I've
never seen something like that. Perhaps the Commonwealth there is this one case, Evans, where something was turned over along these lines. I had never seen it.
Because obviously, if it's exculpatory, it doesn't matter who writes it. It still has to be turned over.
Presumably, there's a police report that's based on, right, somewhere, or notes somewhere that's based on, and that is what didn't get turned over. And this somehow is in the file and did get turned over. So the reason those things don't get turned over is because there's already a police report that already reflects that internal memo and everything that the police learned from that. But that interview recording or notes or a police report, which was a real obvious thing that they would have to turn over. I mean, it was the big interview from the night of the murder of the percipient witness. Obviously, some notes were taken, and probably a police report was made, but it didn't get turned over. And so, of course, the defense lawyers are like, "Where's our report? Where's the notes about what happened that night?"
Counsel, can I ask you? So you were saying that the Commonwealth benefited by saying Benny's story has been consistent. What was the other benefit that the Commonwealth took by the failure to disclose the Goodell memo?
Well, they
Did they say that no cocaine was
They
found
were
in
able to
the
say no
house?
cocaine throughout all the proceedings. They were able to say no cocaine, and the Commonwealth couldn't, the defendant couldn't say well, wait a minute. Let's get Robert Flynn on the stand and figure out what happened here. They didn't know to do that, basically. And then, I would say if there's any question at all about whether or not these statements were turned over, you only have to look at the closing where first the defense says to the jury, no statements have been turned over about this interview, and tries to kind of make some hay out of that. And then the Commonwealth, 11 pages later, says it's true. No record was made of this interview, and you shouldn't make anything of that. They just didn't make any notes. And then he says, I think that is true. Like the prosecutor actually says that to the jury. They say, there's no notes. I think that is true. So he's also vouching for the detectives there. If that's not prejudice, I don't know what is.
I mean, I get you. I mean, I read the closing. Both the prosecutor and defense counsel are both of them make the point. There are no notes. No one took notes. So I'm there on the disclosure point. The problem I have is, okay, take these facts that we got. If the closing read as follows, Benny said he's upstairs sometimes and downstairs sometimes. It seems immaterial to me. The same thing about whether they found cocaine in the house or not. Because if he's upstairs, your client may have walked off with the cocaine before the altercation, and if they're downstairs, I just don't understand how it would be any. I get that Benny is shown in the closing to be clearly involved in the drug dealing. There's a very persuasive point that he's taken stuff to his girlfriend to hide the paraphernalia and other things. So, okay, if this were turned over, there would be arguments to the effect that Benny is inconsistent about whether he's downstairs or upstairs. And Benny is inconsistent about whether there's cocaine in the house when they leave or not. I just don't know why that makes any difference here.
Well, the facts absolutely make a big difference.
Well, tell me, go ahead, redo the closing a little bit for me, and tell me how the jury might have been influenced by the fact that Benny at one point said he was downstairs versus upstairs, or that there was cocaine in the house or not in the house. How is the jury?
Benny is making this up to protect himself. He was there, Mr. Pope was there doing a drug deal.
But Mr. Kelleher does a wonderful job of that. He basically shows this is nonsense. How does Mr. Pope, he deals with him at work. They're selling drugs. He's been to the house multiple times. They're in cahoots with each other.
So a few things. First of all, the standard here, as the Commonwealth has acknowledged, is whether it might have affected the outcome of the trial. This is the lowest possible Brady standard. So we're talking about whether it might have affected it. The facts that Benny makes up that are not in the night of the murder are exactly the facts that this court relies on in determining that Mr. Pope was upstairs doing some kind of prearranged plan. That's exactly that Mr. Hamilton came upstairs, that they left together, that he was there as soon as the shotgun shot happened. Those facts, had they been at issue, perhaps this court would have said, you're right, there is not sufficient evidence of a felony murder because we don't see that there was an underlying predicate. It's not just about the murder. The facts at issue go to whether or not there was an underlying predicate felony of the robbery of both the brothers. So the facts were really, really important. Remember, the judge had already said you can't do a
and I don't mean to belabor this because I'm really struggling with this because I agree with you there's adequate proof of non-disclosure, but I'm trying to understand why you're prejudiced again. But okay, so if Benny is downstairs, if Pope is downstairs, he's there at the shooting. That's bad, right?
Well, the court has already told the Commonwealth, sorry, joint venture doesn't work. You can't use that theory because, for whatever reason, but another guy had the shotgun. Remember, the shotgun is found on a third person that is not Mr. Hamilton or Mr. Pope. So the defense really is, these guys didn't have anything to do with it. It was another person who actually committed this crime. That's important. I'm sorry, I missed the rest of your...
You've done a good job, so I get it, I think I...
If there are any other questions from the court, I would like to quickly address the felony murder question. If Madam Chief Justice, you're okay with that, if you could just give me a minute.
1 minute.
1 minute.
1 minute, yep.
So the rationale for not giving somewhat limited retroactivity to the Brown issue, to the Brown rule, is that there might be prejudice to the Commonwealth. It might be unfair to the Commonwealth to allow people to go back and challenge their convictions. But here the Commonwealth has said, there's no prejudice to us. We acknowledge that there was no other way to find this man guilty. We used the felony murder rule. We were on notice that it might be challenged.
But don't you think he could have been convicted of felony murder post-Brown?
No.
Really?
No, the Commonwealth has agreed that he could not.
I know what the Commonwealth said. Here we have two guys under the Commonwealth theory who go into a drug rip. One's armed with a shotgun and one's armed with a pistol. There's no third-pronged malice there?
There is no felony, there's no underlying felony. I'm sorry, there is an underlying felony at most on the Commonwealth's argument.
Armed robbery.
There's an armed robbery. Mr. Pope is in a different part of the house. He doesn't share Mr. Hamilton's intent. Not that we're saying that Mr. Hamilton actually committed this crime, but he wouldn't have shared Mr. Hamilton's intent. Going through the Brown analysis of why it doesn't make any sense to hold someone accountable who's not part of the crime, I think, no, you don't have any other.
But here we had felony murder that was the basis of the conviction, correct?
Right.
And this court affirmed felony murder on...
Without all the facts, but yes.
Thank you. The court affirmed felony murder, correct?
Correct.
And what's missing in Brown is the element of malice, correct?
Right.
Constructive malice is gone, so now we need one of the three prongs of malice.
Full malice, yes.
Well, no, you need one of the three prongs of malice, right? All right.
Thank
Okay.
you, Your Honors.
Thank you. Okay, Attorney Lynn.
Good morning, Madam Chief Justice, members of the court. May it please the court, Paul Lynn for the Commonwealth. Before we get into the details of the case, I would like to speak briefly about the burden of proof, because both my brother and the amici raised that point. This court has repeatedly stated in cases like Comida that when a defendant files a motion for a new trial, the burden is on him to prove any facts that are not apparent from the record. The argument that the Commonwealth is in a better position to determine whether or not a document was disclosed is completely baseless in any case before 1994, when we were required to begin preparing discovery reports. And now any case that you look at, especially a homicide case after 1994, has volumes of discovery notices. But in 1985, things were much less formal. I've looked through the file in this case. There's one discovery letter that I found, and it pertains to a police report regarding Hamilton. And we know that the defense got more than that because they admittedly got the Flynn report and other police reports by the witnesses in this case.
But this is kind of a different kind, over here.
Sorry.
Attorney Lynn. This is sort of a different kind of report, isn't it? Wasn't this more of an internal report that DAs wouldn't typically be thinking of turning over at that point in time?
Certainly not as a matter of course, but even at the time they're required to disclose at least a prior inconsistent statement of the defendant. Whether or not they disclosed the entire Goodale report, they were at the very least required to disclose that Benny had made a statement and that that statement conflicted in some ways with his trial testimony.
You conceded this is Brady, right, material?
Yes, yeah, we had a duty to disclose these inconsistent statements under Brady. It's Brady evidence. We are not saying,
The issue really is Mazza.
yes,
And so we have a witness who's all over the place.
correct.
Why wouldn't the lawyers continue to say that Benny's all over the place? He's the key witness.
He certainly is the key witness. I'm not denying that. The reason they didn't is because they had so much to start with. They already had.
Do you know a lot of defense attorneys who have impeachment material who say good enough? Have you seen that in murder trials? Because I haven't.
No. But also, there's the question of admissibility, too.
But does it, if it's Brady material, it doesn't matter. I mean, they could have called Goodale. They could have asked somebody. I mean, that's the problem.
Oh, no, I mean, it's the problem is we're essentially arguing in circles. We're saying they didn't have they didn't have the report, therefore they didn't have this information, and therefore that shows that they didn't have the report. It's...
No, I get it. We're in the Mazza world, so we have to intuit whether or not there was a non-disclosure based upon what happened during the examination by Kelleher, during the closing arguments, et cetera. Correct?
Isn't this easier than Massa, though, for him? Because, I mean, the defense counsel gets right up and says, there are no notes by anyone here. And then the prosecution gets up and says, yep, there are no notes. And if there were any notes, they would be using them, essentially. Don't you lose on the disclosure point, obviously, and we got to go to prejudice?
I don't think so, because it's not exactly what they say. They say there's no police notes, and then the prosecutor tacks on at the end. I don't think anybody made any notes. That doesn't mean he didn't turn over the Goodale document months earlier.
Really?
But,
I mean, I can read this to you, but it's pretty damning. I mean, the language, you know, he says there are no notes from anybody.
Let's assume that you lose on that point.
I will move on. One thing I'll point out, one thing that stays consistent through all the statements, including the statement that Benny made to the police that's memorialized in the Goodale memorandum, is that the defendant put a gun to Benny's head. That never changes. But also, I found...
But if we can't believe Benny, because Benny tells different stories, don't you have a problem?
If this was the only impeachment evidence, that would be a problem. But I want to bring out what defense counsel did bring out. And this I found while I was preparing for argument. This is the first trial, 1985 trial, volume 4, pages 51 and 52. It's cross-examination of Benny by Attorney Kelleher for the defendant Pope. Question, did you introduce him, meaning Pope, to your brother for the purposes of buying and selling cocaine? Answer, yes, sir. Question, and you knew that was against the law, did you not? Answer, yes, sir. Question, you knew that you were actually entering into a conspiracy to distribute cocaine in the state, did you not? Answer, yes, sir. Question, you knew that distributing cocaine was a felony in this state, didn't you?
Would you agree
Answer,
that
yes,
this
sir.
case hinged on Benny's credibility?
Yes, there's no question of that. He is the key witness.
Then I think you got a problem.
And he goes on, the next question is, yet you participated in the handling of the money and the handling of the cocaine, didn't you? Answer, yes, sir. And at both trials, Benny repeatedly admits that he held himself out to the public as the drug dealer. The defense also knew that Benny had told the officers at the scene, or had not told the officers at the scene that he'd
So,
gone to his
counsel,
girlfriend's home.
Can I stop you in
Yes.
the recitation? Because you know, time is short and we've
Yes.
read the record. So the first thing, so regardless of the burden of proof, the disclosure issue doesn't really go well for the government, right? Because, you know, as Justice Gaziano was pointing out, this adds more impeachment to the only key witness putting Mr. Pope in this position. And so there's more lying by the key witness. So the Mazza rule really indicates that there probably wasn't any disclosure. You admit that this was a Brady violation. I guess, and given that it is a Brady violation, a non-disclosure issue, not a late disclosure, the prejudice that Mr. Pope needs to show is very low. Given that, how do you think the Commonwealth wins nonetheless?
Because here, the addition of this one additional statement, which is why I'm making this recitation, was so minimal that it could not possibly have affected the verdict.
I'd push back on that because you're completely discounting the timing. When was the timing of this interview with Mr. De Jesus that we're talking about?
The interview was after the defendant had made the statement at the scene, but the same night. So
It was the same night,
correct.
okay? And we know what lawyers do about memories, right?
Right?
Okay, so the same night is when he makes all of these inconsistent statements. In terms of kind of persuasive force, it's really powerful, right? Isn't that the stuff that the defense lawyer is going to stand up and say and hammer to the jury that the same night he makes all of these inconsistent statements that puts Mr. Pope in all of these really compromising and incriminating positions?
I would argue no, because his statement is not particularly inconsistent with his statement, is not materially inconsistent with his statement he makes at the scene. It's basically a case of things that he omits saying on the night of the murder. For example, the whole upstairs-downstairs issue. Officer Flynn testifies at the first trial that Benny told him that after the shooting, he started going downstairs. And as he was going downstairs, he met the two assailants coming up the stairs, which means, of course, that Pope was downstairs at the time of the shooting. So the defense already knows that at the moments after the crime, Benny is telling a story that is inconsistent with his story that he tells at trial, when his memory is absolutely fresh enough that they could have brought the defendants back and done a show-up at this point. That's how soon after the crime that Benny makes this statement to Officer Flynn. In fact, contrary to my brother's position now, in Pope's closing argument, this is volume 7, page 36 of the first trial, counsel for Pope calls the Flynn report, quote, very comprehensive, and argues that it shows that Benny went downstairs after the shooting. He also argues at the second trial that he takes a different tack and argues that the fact that Benny is upstairs actually hurts the Commonwealth, because if he's upstairs, why didn't he steal the cocaine before the shooting? Why is he even upstairs? Why is he still hanging around?
Mr. Pope, right? You mean Mr. Pope, right? Not Benny.
Oh, sorry, yes, I am very sorry if I said Benny. Mr. Pope, why is he upstairs? Because he could have stolen the cocaine then. Why does he have to commit an armed robbery of someone he knows and who knows him? Turning to the cocaine, I'd first
Can I ask you to turn to the Commonwealth's use of the failure to disclose in its closing argument?
That what the Commonwealth argues in its closing argument is this issue of whether or not Benny was the drug dealer, and this is at both trials. He says is a red herring. It's a distraction. That's not the charge. At the second trial, he does add a tag, said there's no evidence of that, but that's because the defense didn't take that tack at the second trial. So he's correct. He's not arguing there's no information that shows that he's the drug dealer. He's just saying that's not what's at issue here. It's a red herring. It's a distraction. And I would urge this court to realize that on appeal, too. It's a distraction.
Is that the standard for a Brady violation?
I don't understand what you mean by this, Your Honor. I'm sorry.
Well, I guess, to show prejudice for a Brady violation, as I was articulating earlier is a very low bar.
It's a low bar, but here it doesn't even come close.
You're saying it was completely immaterial.
Completely immaterial. It adds, what it adds to the cross-examination at trial is de
Even though it was
minimis.
used in closing argument.
It was not. That's what I just argued, Your Honor. It was not used to any effect in closing argument. But I cannot emphasize strongly enough that what Attorney ADA Goodale argues or states in the Goodale report.
Can I read what he actually said? So this is Mr. Fucillo, I can't remember who.
Yes, the prosecutor.
So the prosecutor goes, Curran took no notes. Nobody did. I think that's true. Did he ask the officers, are there any other reports? Did he ask the officers, the other officers? Did he ask Baker? Did Baker make any reports? Did he ask Curran? Whether or not, besides writing anything down, whether or not Curran taped conversations of any of these people, no. Why is that? Could have, sure. But if he has that document, can he start pointing out that there are notes here and Benny's off the reservation?
Again, I would point out that what the defense argues in closing.
That's accurate, right? The Commonwealth is using this no-note point to its advantage, right?
I could not possibly disagree more with that statement, Your Honor.
I'm just reading the language.
Yes.
Why am I misinterpreting it?
Because the defense argues in his closing that the absence of notes indicates incompetence by the police. If they didn't make notes, then they were incompetent. And that's a Bowden defense. And the prosecutor responds saying, it doesn't matter. Did he make notes? Did he not make notes? It doesn't matter. That's the Commonwealth's whole point about the entire Benny notes thing. It doesn't matter. Not so much that you should find that there were notes or there were no, or excuse me, I should say that you should find that.
But counsel, that's based on a misinformation. That's the predicate for why defense counsel is saying that is because that's all he knew. If he knew that it also included all of these inconsistent statements, that the closing argument's going to be different. It's not going to be focused on Bowden. It's going to be focused on the inconsistent statements.
It was focused on the inconsistent statements.
I'm speaking specifically about the report.
That's true. But there's
Rather than argue that there's no report, and therefore it's a Bowden issue, it wouldn't be even talked about in that way. It would be talked about the content, the impeachment content that's in the report.
But it was. I mean, granted, he did not mention the report in particular, but he did mention all the other reports. That was the heart of the defense, and I want to get this out in the last 20 seconds. It's crucial to realize that what Officer Flynn told the ADA in the Goodale report is that he saw what he thought was cocaine, not that the cocaine was recovered. And at the trial, Detective Curran testifies that the very purpose of burn is to make it look like packets of cocaine. And so the question here is, what is worse? Evidence that he's a drug dealer and has cocaine, or evidence that he's a drug dealer, this is Benny, of course, evidence that Benny is a drug dealer who's ripping people off. That's what the defense was. If you look.
Well, here's the issue that I think you'll agree with, though, which is I understand the burden and issues of impeachment and motions for new trial in and of themselves are not enough. But here, your argument seems to be, well, he was already cross-examined thoroughly, impeached thoroughly. That's the thrust of the closing, so there's no prejudice.
Correct.
But the argument here is that it's a specific request for Brady.
Correct.
And with the specific request, not only was he lying or saying inconsistent statements in this pile, there's a whole other pile that the defense attorney might have been able to use to impeach. There was more evidence they could use to impeach, and that would have thickened the stew of the quality of the impeachment. It's a one witness case.
It is a one witness case, but when you look at this evidence, he is cross-examined on the exact same points that are omitted from the statement he made to the police. It is exactly the same. It is the same context. It is the same issues. It is the same. There is no reasonable possibility that this could have affected the verdicts.
Doesn't
I see
thicken
my
the
time
proof?
is up.
It doesn't thicken the proof? It doesn't thicken the quality of the impeachment?
Not that any jury would notice, no. I see my time is up. If the court has any questions regarding the felony murder rule, I would address it, but otherwise I would rest on my brief.
I think we're all set.